everybody. It's 12:02, so we get to start our webinar, and hopefully a few more people will join us as we go along. Well, my name is Pinar Karaca-Mandic. I'm a professor, a health economist at the University of Minnesota's Carlson School of Management. And we wanted to welcome you to this very last event of this academic year, the 2021-22 academic year of the Business Advancement Center for Health, or BACH for short, that we launched just this past January. As the founding director of BACH, I'm really excited to spearhead this new research center to really reimagining health and healthcare through designing and evaluating the next generation of business models and thinking very innovatively about our healthcare industry. We are so excited today for this event where we will be talking about the 340B program, which you will learn all about the 340B program, an exciting program that was established in 1992. So we are at its 30-year anniversary. Really, the goal of this event was to provide substantial outpatient drug discounts to eligible providers with that intended goal to really reach the safety net, to help fund activities of the safety net for vulnerable and often uninsured patients. And the program has seen tremendous growth in all dimensions, growth in clinics and hospitals participating. And today's topic, we are particularly going to be talking about the contract pharmacies that are part of the program. We have a really exciting panelist group. We have Professor Sayah Nikpay, my colleague at the University of Minnesota, Associate Professor in the Division of Health Policy and Management School of Public Health. We have Tom Barker, a JD and partner at Foley, Hoag, LLP, and Faraz Siddiqui, who's a JD and associate at Hyman, Phelps, and McNamara, PC. So I just am going to invite our panelists right away and have them each introduce themselves. Sayah, we could start with you.
Thank you, Pinar. I'm very happy to be here. As Pinar said, I am an associate professor in the School of Public Health. I'm a health economist. I am someone who studies the healthcare safety net and financing of the healthcare safety net, which is why I'm so passionate about 340B. I have a lot of direct experience working with policymakers. I was at the White House Council of Economic Advisors. I've worked with McPAC and also several state governments, including the state of Michigan. And I'm very happy to talk about my work and others' work on the 340B program and what we know.
Thank you so much, Sayah. Faraz, would you like to introduce yourself?
Yeah, hi everyone. I'd just like to thank Pinar, Josh, and the Carlson School for inviting me to speak. I'm Faraz Siddiqui. I'm an attorney with Hyman, Phelps, and McNamara. We are a small law firm based in Washington, D.C. We mostly represent FDA-regulated companies like pharmaceutical companies, medical device, and food companies. The firm has a lot of clients that are generic drug manufacturers, startups, small companies that are working on rare diseases. As for myself, my practice includes helping and advising clients on drug development issues, as well as issues related to government drug pricing programs such as Medicare and Medicaid, and the 340B program that we are talking about today. I have before I started the practice of law, I worked as a public health researcher and epidemiologist, and hopefully, bring that perspective into my work.
Thank you, Faraz. Tom?
Thank you, Pinar, and thanks to my fellow panelists and to the Carlson School for the invitation. My name's Tom Barker. As Pinar said, I'm a partner at the law firm of Foley Hoag in Washington, D.C. I co-chair our healthcare practice, and I'm also on the faculty of George Washington University School of Law, where I teach a course in Introduction to Healthcare Law. My practice is very similar to Faraz's in the sense that I represent mainly life sciences companies, pharmaceutical, biotech, medical device manufacturers, but Faraz's practice is more maybe on the FDA side. Mine is more on the coverage, coding, and reimbursement side. I help manufacturers navigate Medicare and Medicaid, commercial insurance, coding, coverage, reimbursement, payment type issues. And to that extent, do a lot of work in the 340B program. And so I'm happy to be on this panel today. I'm going to be giving the provider perspective and look forward to everyone's presentation.
Thank you so much, and thank you all the panelists, and thank you to the audience. Just a house rule. So if you have questions, please use the Q&A to ask questions throughout. We will have a little bit of a time at the end for actually answering questions directly coming from the audience as much as we can. So we encourage you to submit some questions. Yeah. So as you heard, as you've seen, we have such a diverse expertise group here, talking both in terms of the litigation, but that's also from the provider, manufacturer side, provider side, and then Sayah bringing these research insights, both from her research and the growing body of really research in the 340B program overall. So why don't we start with Sayah? If you could give us a little bit of an overview of the 340B program, what is a contract pharmacy, and what do we know about the research and the data and the gaps? Thank you.
Wonderful. Can everyone see my slides? Wonderful. Okay. So I think it's impossible to talk about 340B without some type of visual aids. This program is very complicated and has a long history of complication upon complication upon complication. So let me just say that, a persistent feature of our healthcare system has been rising healthcare costs, and a lot of Americans use prescription drugs. So policymakers are often interested in levers that they can pull to increase access to prescription drugs and potentially increase access to those drugs at a good price. What's in a policymaker's toolkit falls into what I think of as one of three buckets. We've got state efforts to actually regulate prices directly. We've got coverage expansions like Medicaid or Medicare Part D program in the mid-2000s. But then we have this sort of hidden type of policy that many people don't really think about, which is special prices for safety net providers or safety net agencies. Now, this figure is a little bit out of date, but I like it for teaching purposes because it sort of shows the differences in prices that people get across programs. So if you think of what's in brackets as private prices, we can start with something like the green bar, which is average wholesale prices. We like to think of that as a sticker price for drugs. Medicaid is getting a discount based on the Medicaid rebate program. That's an important special pricing program of about 60% of that average wholesale price. For something like the VA, they're getting an even deeper discount relative to those sticker prices. Their special pricing mechanisms put them about at a third of that list price. But we have the 340B program right here in the middle, which is, as of the time that this slide was made, is giving a discount of about 50% relative to those sticker prices, we think. And today, exercises have actually, federal government agencies have done some exercises with limited sets of drugs to actually figure out, how big are these discounts that providers get through 340B? How big are they relative to Medicare reimbursement? And it turns out they're about, on average, 40% of what Medicare reimburses for drugs. And for about 80% of those drugs, it's going to be, it's a pretty big discount off of Medicare's reimbursement. So what is this program? As Pinar mentioned, it's a 30-year-old program created in 1992 on the tails of the Medicaid drug rebate program. The point of this program was to help providers who don't necessarily have tons of Medicaid patients, but do have a lot of uninsured patients or other types of patients that aren't going to benefit from Medicaid drug rebates. The point was to help them by giving those providers discounts, big discounts, on outpatient drugs. And there's sort of key language underlying the statute or in the regulations for the 340B program. The goal, in addition to providing discounted drugs that you could use on patients, the goal is to allow providers to stretch federal resources as far as possible, reaching more eligible patients and providing more comprehensive services. In general, what providers have taken that to mean is you can use spread pricing to charge insured patients full price for discounted drugs. I'll elaborate on what that means in a second. HRSA is the agency that is in charge of regulating 340B. It's the Health Resources and Services Administration, and you'll recognize it from many safety net programs Office of Rural Health, and many others. So in terms of who can participate in this program, we've got two main types of safety net providers that can participate. In gold, you'll see the federal grantees. Those are classic example is like a federally qualified health center. But in blue above, you see we have a bunch of different types of hospitals that can participate. The biggest category of hospitals that can participate are going to be dish hospitals, but there are these other types of hospitals that can participate too. Now, the key thing to note is that all of the providers' drugs are eligible for these big discounts that 340B provides, not just safety net patients. So the, for the federal grantees, the payer mix at a lot of those places is heavily skewed towards uninsured patients. At hospitals, the payer mix is heavily skewed towards insured patients. And so this provides an opportunity for spread pricing. So how does this program work? This schematic, I think, is a very basic idea here. Basically, the 340B entity acquires drugs at a discounted cost in step one. In step two, patients receive care with those drugs. And in step three, the hospital or other covered entity bills that patient's insurance, and they collect a copay from the patient, they collect the reimbursement from the insurer, but they are able to pocket the spread basically between the full reimbursement received from both patient and the insurer, and profit from the difference between reimbursements and the special 340B pricing. And I should say the value of this of those savings was estimated to be around $15 billion by Adam Fine at Drug Channels. Okay. So and I should say that the key thing to note here is that those savings, those $15 billion of savings, there are no requirements that they be reported, that they have to explicitly be used for safety net purposes, such as in compensated care. And also, covered entities are not required to pass savings on to indigent patients. So it really is very loosely, they're loose in terms of rules. So today, 340B covered prescriptions have exploded. Today, it's about 7.2% of the prescription drug market. And 340B eligible drugs discounts can be claimed in two different settings, either through the outpatient clinic setting where drugs might be infused. And there are today 51,000 total called child sites where these drugs can be administered. But in a growing space, we also have outpatient pharmacy dispensed drugs. So these are drugs dispensed through in-house pharmacies or retail pharmacies that are contracting with the 340B program. And it's estimated that this is about 30% of program sales in 2020. We actually know a growing amount of findings from the clinic physician administered drug space. And generally what we find is that hospitals are more likely to locate these clinics where you can distribute 340B drugs in places where they can maximize that difference between reimbursement and the discounted drugs, so higher income areas. The participation in 340B does not appear to be systematically associated with any bump up in safety net engagement measured by a variety of different outcomes. 340B may also, some research suggests that 340B may be fueling consolidation as hospitals reach out to acquire clinics that administer infused drugs. And then finally, there are a number of papers that find that 340B may increase drug spending relative to what that provider would have spent on drugs otherwise. So that's in the clinic physician administered drug space. But really, contract pharmacies, which are the topic of today, they have increased substantially over time. In blue, you will see that there were very few pharmacies, contract pharmacies, or even in-house pharmacies participating in this program before 2010. What happened in 2010 is that HRSA said that they removed a cap. There used to be a cap of one contract pharmacy per hospital. And the goal of that contract pharmacy was to allow patients to more easily access drugs in the community. In 2010, regulations were written that stated that there's no cap and 340B covered entities can establish an unlimited number of contracts that are not bound by geographic restrictions or anything of that nature. So we see that the number of sites at which 340B discounted drugs are being provided explodes. So there's very little research on contract pharmacies. I'm going to briefly walk you through what we know and then talk about the gaps. We have some reports from industry-funded studies that suggest that the profits from contract pharmacies are actually quite large. This study by BRG Group estimated that the average margin on prescription drugs when you are participating in 340B goes from 11% to about 72%. So it makes sense that this is actually a really attractive program. This is from a paper that I actually just came out with. We look at the spread, we look at the growth of contract pharmacies across communities over a decade before and after lifting of the cap. And what we find is that for DISH hospitals, we went from only about 3% of counties having a pharmacy to upwards of 3/4 of them having a contract with a DISH hospital. And it turns out that the pattern of growth over that time isn't really related to safety net demand. And in fact, it's actually negatively related to some measures of demand for safety net care. The federal grantees, on the other hand, they've had some amount of growth, but it looks like the places that added contract pharmacies tended to have more safety net patients than not. There's also some work, we really have to rely on OIG and GAO for a lot of the research here on 340B contract pharmacies, because those are the only agencies that are able to compel 340B covered entities to reveal information about the program. I like showing this slide because what it shows is that among a sample of contract pharmacies, there were many contracts that did not allow for discounts for indigent patients. So what this means is that an indigent patient would walk up to a CVS pharmacy, they're potentially a patient of a safety net hospital, and that pharmacy would charge them the full price for that drug and not the 340B discounted price. So I would argue that this is potentially a problem. And then finally, a kind of stylized fact about these contract pharmacy markets is that the contracts are heavily dominated by for-profit retail chains. So the three largest chains are CVS Health, Walgreens, and Walmart, and they together share constitute the lion's share of these contract pharmacies. And many of them are already vertically integrated with PBMs, specialty pharmacies, and this may propose a conflict of interest or simply a problem with competition in markets. What we still don't know is simply the size and scope of the savings generated through contract pharmacies, which types of hospitals and clinics are benefiting most, which drugs are affected most. We also don't know the effect of this explosion in contract pharmacies on patient finances. Could this possibly be benefiting patients? Evidence from GAO suggests maybe not. And in fact, if there's some evidence from other safety net pricing programs suggests that over time, pharmaceutical manufacturers may raise their prices in order to minimize the value of these discounts. And so we may all sort of not benefit. We may all be hurt by this program in a general equilibrium sense. And then finally, we don't know what the impact of 340B contracts are on pharmacy markets broadly. We know that they are already very consolidated, and we tend to think that that's bad for consumers. This 340B contracts may be adding fuel to the fire here. All right, and with that, I will conclude.
Wonderful, Sayah. Thank you so much for that extremely insightful and detailed overview. And with that, I will ask Faraz to take the stage next. And if Faraz, you could tell us a little bit more on the litigation front, what is happening, and in particular, if you could tell us a little bit more about the pharmaceutical manufacturer perspectives.
Thank you, Pinar, and thank you, Dr. Sayah, for such a great overview. I'm not envious of what you had to do in explain such a complex system. In the last couple of years or so, there's been all sorts of different litigations going on in this area, in the 340B area. With regards to contract pharmacies, what I'll do is I'll paint a little bit of a picture. I'll set the stage of what's happening in the courts in the current litigation. And then, as Pinar mentioned, give the most salient arguments that the pharmaceutical companies, the industry is making in these lawsuits. So around a year and a half ago, in August 2020, 6 drug manufacturers announced that they will start restricting how they provide 340B drug prices to covered entities. They said 3 of the drug companies said they are going to provide 340B prices only to covered entities that have an in-house pharmacy. So this is going back to how the 340B program was operating before 2010. You'll remember from Sayah's graph over there. Or if a covered entity is too small that it can't have an in-house pharmacy, then those covered entities that only have a single pharmacy that they contract with. 3 other companies said that what they'll do is they will provide 340B prices to any entity that can provide claims data from all their contract pharmacies, so that they can then come over and audit those claims data themselves to see if there's been any duplicate discounting. And I'll talk about duplicate discounting in a little bit. One point to note over here is that when the drug companies took this step, they insisted that their position is in line with current law. And as you will see, at least some of the courts have, agreed with them in principle. However, the flip side of this is that there are heavy fines that they can face if a drug company denies a 340B price to a covered entity that is otherwise eligible to get that. So a few months after that, in December 2020, the General Counsel of HRSA issued an advisory opinion saying that the 340B statute actually allows for multiple contract pharmacy. The General Counsel looked through the statutory language and made their own interpretation and said that because of this, the drug manufacturers are required to offer the 340B prices to any covered entity, regardless of the number of contract pharmacies they have. The drug companies did not agree with that, and so they sued in January 2021. Several manufacturers sued the government. They filed these lawsuits all over the country, in Delaware, New Jersey, as far as Indiana and Maryland. So it's a different areas, different circuits of the federal judiciary. So we can expect that there may be some differences of opinion between the courts. So even though this had gone to the courts, the HRSA decided that we are going to press ahead with our view of the agency's view of what the statute says, and send letters to all the 6 manufacturing companies, threatening to start fining them. And these fines can actually be significant, almost $6,000 for every single order that does not provide a discount when one is required. So some of the lawsuits actually put together a calculation of how much they could be liable for paying because of how large the 340B program is, and it really runs into the hundreds of millions of dollars. We have 6 lawsuits. All of them are quite lengthy. They touch on many different aspects of this question. So I'll just touch on a few important points. First of all, all the lawsuits have to grapple with the idea that the word contract pharmacy doesn't actually exist in the statutory language. So, are contract pharmacies allowed or not allowed? Only one is allowed, or many are allowed? We don't know, at least from what Congress said. Now, there is a little bit of the discussion that Congress had at the time that this law was enacted, but it doesn't really definitively answer the question. The providers, they argue that 340B entities get this discount no matter where they dispense their drugs from, which could be from any number of contract pharmacies. And then there's some other issues in terms of the advisory opinion that was sent and the letters threatening enforcement. So at the right now, there have been 4 rulings of the issue. 2 of them found for HRSA, saying that HRSA had the authority to deliver the warnings to the companies and can actually act on them. 2 other courts said that no, those letters are not were not lawful, and they struck down the letters. What had set the stage, at least a little bit before that, was that the first court that came out with an opinion, the Delaware court, they decided that the advisory opinion that was set up was on faulty legal grounds, and it seems that all the courts have actually agreed to that. That HRSA can just by writing an advisory opinion talk about what the law means, how to interpret the law. That's that's what the courts do. So even though that was thrown out, HRSA had continued to seek enforcement and threaten with the fines. So that's what I meant. 2 courts decided for HRSA, 2 against. So one of the courts, the Indiana court, actually found something that was a little bit more nuanced. According to the reading of the statute, this court said that a drug company cannot restrict the 340B price to a covered entity based solely on the delivery location or the dispensing mechanism. So they agreed with what HRSA was saying or what the providers were saying. However, they found some procedural errors in how HRSA flip-flopped on the issue. In 2010, HRSA said that you can have as many contract pharmacies as you want, but 15 years prior, in 1996, they had said the exact opposite, that there's only one contract pharmacy that's allowed. So because of these changes, the court decided that at the very least, HRSA cannot fine the manufacturers for restricting some of the 340B drug prices. So, okay, so that's just to set the stage and what's going on, what the questions that are up in front of the courts. Let's get into some of the issues, some of the arguments that the providers are making. So, one thing that we have to understand is that these lawsuits are not completely out of the blue. It's not that one day the companies decided that, hey, we are not going to provide these discounts that we have for at least a few decades. The background of this is, though, that nobody expected, at least of all Congress, that 340B would expand so much, balloon so much that each and every little administrative issue would cost millions and millions of dollars. So the stakes are high over here. The pharmaceutical companies asked HRSA to change some of the regulations, change some of the oversights, some of its oversight to make sure that the covered entities are acting in compliance with the law. And after several years of working with HRSA, not getting any response, they went ahead and made their own decision and now are in litigation. It's the position of the pharmaceutical companies that the 340B program was, in spirit, was designed to actually pass the discounts to the patient, even though, as Sayah said, it doesn't say that in the statutory language. The companies, the covered entities can pocket some of the money to provide some other services. But what the 340B program definitely did not do is to have the contract pharmacies pocket some of the profits. And we see that there's a lot of big chains, pharmacy chains that have done that get at least some of the cuts. So may get some of the cuts from of some profit from dispensing 340B medicines. Okay. So just in my closing minutes, I'll talk about the 2 main arguments that the companies make. One of them is called duplicate discounting. In this, what happens is, imagine there's a covered entity, a children's hospital, and they see patients, and the Children's Hospital gets all their medicine, all their outpatient drugs discounted through the 340B program. They see some patients, and some of their patients are Medicaid patients. When they bill the government for the services that they gave the Medicaid patients, they include the money for the drugs that they gave to the patient. That goes over to Medicaid, who reimburses the company. That reimburses the covered entity. In the Medicaid program, drug manufacturers have to give the government a discount for any medicine, any outpatient drugs that the companies sell to Medicaid, except if they are already discounted by the 340B program. So what has been happening is that the various states and the various covered entities have not been tracking how well, have not been tracking the 340B and the Medicaid discounts separately. And sometimes the same medicine gets twice the amount of discount, or duplicates the discount. And HRSA does not really have a good oversight on this issue to see how to make sure that the covered entities are actually keeping those apart, how they're tracking what drugs that they have that have already been discounted under the 340B program. And it's not just the drug companies that are making this argument. In 2018, the Government Accountability Office found that HRSA's oversight over duplicate discounting had several weaknesses. The regulations don't allow HRSA to properly evaluate the program providers. The providers have in place to stop this kind of practice, and really no teeth to ensure that they comply if a duplicate discounting is found. The other thing is called diversion, and just in brief, a covered entity gets 340B, buys 340B drugs at discount, has them shipped to the contract pharmacies, and then the contract pharmacies and/or the covered entities sell that to non-340B patients for a lot of profit, because now they can give them prices on 340B patients, prices that are close to commercial prices. So, again, even as early as 2014, the Office of Inspector General at the HHS found that this diversion, this is the issue of diversion of 340B drugs was going to non-340B patients, and really, again, causing in the end an increase in prices, because it wasn't really going to the right people, but was being spread over many more people patients who weren't even eligible for that. So that hopefully gives a good idea and background of how the pharmaceutical companies in these litigations have entered the debate on contract pharmacies.
Wonderful, Faraz. Thank you so much. It's Sayah started with this complicated picture, and then now it becomes even more complicated when the litigation is layered on top. But you've done a great job highlighting those big issues. Thank you. Now we move to Tom. Tom, we heard from Sayah the research needs and the gaps in the data, and Faraz highlighted the litigation. And again, as a researcher myself, I see even more research and data gaps, like when you talk about the duplication, Faraz, that idea that we don't have tracking systems to figure out how to solve the problem, and maybe that's something where we need more data. Tom, if you could explain a little bit more about the provider perspective here and the concerns. And of course, as a former HHS Deputy General Counsel yourself, and if you could comment on the questions on that HHS legal authority, and to what extent HRSA has binding regulatory authority or not in that particular regulatory space. Thank you.
Sure, thanks, Pinar. And Faraz, thanks for that explanation. I think you did a really good job explaining the dilemma that HHS finds itself in enforcing the 340B program. So I'm going to say a little bit about provider perspective, and then I want to hone in a little bit on the legal nuances and the challenges, both from the perspective of providers and also from the perspective of HHS in implementing and living with the 340B program. So from the perspective of providers, covered entities, and especially those covered entities that are hospitals, they see the 340B program as a lifeline in a time of funding shortfalls, especially funding shortfalls in the Medicare and Medicaid programs. And for those hospitals, especially disproportionate share rural referral centers and pediatric hospitals that see a large publicly insured population, primarily Medicare and Medicaid, upwards of 70 and 80% of their patients are insured under the Medicare and Medicaid programs. They just don't have the ability to cost shift the way non-340B hospitals have the ability to cost shift to commercial insurers. And so the 340B program creates this lifeline, the ability to enhance limited funding. And so, Dr. Nikpay, I really appreciated one slide that you had that showed how the arbitrage works, how a a covered entity can acquire a drug at the 340B discount, and then they turn around and bill the insurer for the drug at the market price. And so there's this delta between the reimbursement amount and the acquisition cost of the drug. And there's no requirement that that be passed on to the patient. But from the perspective of a covered entity, that's okay, because the purpose of the 340B program was, quote, to stretch scarce federal resources as much as possible. And there really is a need for that arbitrage from the perspective of covered entities. They feel, they furthermore feel that they need to have the flexibility to determine how they dispense a covered outpatient drug under the 340B program to a patient. They feel as though they shouldn't be tied to the actual covered entity and only the covered entity, or only the covered entity and one contract pharmacy, which had been the rule prior to 2010. So I want to focus now on some of the legal concerns. And I think the principal legal concerns that covered entities have are, number one, and I will also say, speaking, as Pinar said, I was the acting general counsel of HHS in the Bush administration. And so speaking from HHS perspective, I can also say that there is a problem that we have a vague statute, as complex as it is. We've spent the last 40 minutes talking about how complex the 340B statute is, but as complex as it is, it's also very vague. And so that's problem number one. And problem number two is that there is very limited ability by HRSA, the government agency that's responsible for implementing the 340B program. They have very few tools to enforce the 340B program. And there's sort of a catch-22 here, right? Because in 2011, there was a Supreme Court decision, Astra Pharmaceuticals versus Santa Clara County, where the Supreme Court held that the 340B program cannot be enforced by a private party. A covered entity cannot challenge a manufacturer for failing to comply with the 340B statute. But then a few years, and the Supreme Court said, and only HRSA can enforce the statute. A covered entity, a private party, doesn't have the authority to enforce the 340B statute. But then 3 years later came a decision from the US District Court for the District of Columbia called Pharma versus HHS, in which the court held that HRSA doesn't have regulatory authority in the 340B program, except in three very narrow areas. And so from the perspective of covered entities, and from the perspective of the government, well, it's all well and fine to say that there are these limitations on the ability of a covered entity to dispense drugs, but there's really limited ability for enforcement. So I'll just give you an example. The statute says that a manufacturer, quote, shall offer each covered entity covered outpatient drugs for purchase at or below the ceiling price. That's all the statute says. It doesn't say anything. It doesn't impose any restrictions on the ability of how a covered entity dispenses the drugs that it purchases. Once legal title passes from the manufacturer to the covered entity from the perspective of covered entities and from the perspective of the government in the OGC advisory opinion that Faraz mentioned. A manufacturer doesn't have a continuing right after the drug is sold to control how it's distributed. And so if a covered entity wants to have multiple contract pharmacies, from their perspective, and this was the OGC advisory opinion that came out in the fall of 2020, from the government's perspective as well, once the covered entity acquires a drug, it's up to them to determine how it's going to be dispensed. And that's sort of the dilemma and the heart of the dispute in the litigation that Faraz went through. The law imposes restrictions on what a covered entity can do. For example, they can't resell, they can't divert the drug, they can't be in a situation where there's duplicate they can't create a situation where there's duplicate discounts. But from the perspective of providers, there isn't a further restriction on how they can distribute the drugs, dispense the drugs. And if they want to have multiple contract pharmacies, they feel that they should be able to do that. As I said, there's a real problem because the statute just does not give HRSA enforcement authority in the 340B program, other than in three very narrow areas. Congress told HRSA that they could issue regulations defining ceiling price, that they could issue regulations, dealing with dispute resolution, and they could issue regulations dealing with sanctions. That's it. They can't issue regulations otherwise in the statute, and that under the statute. And that reality, as I mentioned, was affirmed in a 2014 district court opinion, U.S. District Court for the District of Columbia, which was interpreting a regulation that HRSA issued after the ACA passed that limited the ability of the newly expanded covered entities to access 340B pricing for orphan drugs. And HRSA interpreted that statutory provision very, very narrowly and essentially said that a covered entity could acquire an orphan drug if it wasn't dispensed for an off-label indication. And pharma challenged that regulation, that interpretation, and the court invalidated it. And in invalidating that regulation, the court said that HRSA simply doesn't have regulatory authority under the 340B program, again, other than in those three narrow areas: dispute resolution, definition of contract of ceiling price, and sanctions. And that's it. Those are the only areas where 340B, where HRSA has authority to regulate the 340B program. So because of that decision, because of the 2011 Supreme Court decision that I mentioned, there really isn't the opportunity for private parties, covered entities, or for that matter, for HRSA to significantly regulate in the program. And so that's sort of where we are. And I think this is probably a good place for me to stop my comments, and we can open it up for questions, because I know we're going to talk a little bit more about what next steps might be, what might be done to solve this dilemma. But I'll stop here and turn it back over to you, Pinar.
Thank you so much, Tom. I think we can keep on talking more and more about this topic. It's like I'm just beginning to realize we're just sort of peeling the top layer of the onion here. So I want to start with actually a question that came from the audience, and I want to direct it to Sayah, because something else I wanted to ask Sayah was thinking about, the patient. When we think about the patient and putting the patient at the center, right? Going back to this 30-year ago origins of the program, and I really reached to that vulnerable patient. So the question from the audience says, Dr. Nikpay said earlier something to the effect that there is not evidence regarding how the 340B discount is then used for patients. So if you could clarify a little bit, because the attendee is asking, does it mean that there's not comprehensive research that quantifies the benefit, or is it there's a clear benefit that many providers bring to patients through these enhanced services because the extra resources are enabled. We don't know how they are enabled. If you could comment on that a little bit, Sayah, and how do we, and then, how do you think about these contract pharmacy arrangements as well in terms of benefiting the patient?
Yeah, I mean, really, patients are the motivation here, right? We have unaffordable drugs. We want to allow patients to use those drugs. So what we know from the research, the systematic peer-reviewed evidence is that when we look at hospitals that participate in this program as a whole, we don't find that when they start participating in this program, they do anything more than what they were doing already. So you have a hospital that's not eligible, their uncompensated care doesn't go up, they don't do more charity, they don't enhance services that they provide. We don't see hospitals, say, adding a low profit service line after they become eligible. And so, one might say, well, maybe it still just benefits patients because just padding the resources of a safety net provider is valuable in itself. Certainly for the federal grantees who see many uninsured patients or complex patients who may have incomplete insurance, giving them a subsidy of this nature is really beneficial. However, among the hospitals, on that wheel I showed you, they are a very heterogeneous group. You have some hospitals that are going to be public and accept all patients and don't charge all the time. And you also have highly sophisticated organizations that are very good at negotiating rates from insurers that have a lot of market power. And really, we might not call them safety nets. I think a lot of people are really surprised to understand that we don't have one agreed on definition of what a safety net hospital is. And the criteria that we use for things like dish payments actually doesn't reflect anything about uninsured patients at all. It's really about your Medicaid volume. So I would say that, it does, the spread pricing, those savings could potentially just keep that hospital in business. It's great if that hospital was already doing a lot of good things for their, safety net populations. Those patients who have a hard time affording drugs. But, if they weren't really engaging with the safety net that much in the first place, then what's the value of these additional savings? Especially when you can imagine a situation where I like to talk about, think about I believe, a quarter or 1/3 of Medicare beneficiaries who have no supplemental coverage. Someone has cancer, they have to take a course of drugs that may cost $100,000 a year. Medicare Part B has no caps on out-of-pocket costs. That person is going to have to spend $20,000 on that course of medicine. And if that hospital is not cutting them a break at all, that's quite a big, burden for the patient. We call that financial toxicity. And so in this way, we do sort of worry about where these savings are going, since we don't have evidence that hospitals in particular boost those services that they provide to the safety net population after becoming eligible.
Thank you, Sayah. There are two related questions. I don't know, Faraz, if you wanted to take, if you have an answer for these, I want to ask you another question. I want to ask Faraz to you about, you told us a lot about the litigation that is going on currently. I just wanted to see if you could comment a little bit more about, expected timeline and what other next issues we may expect on litigation. But if you're able to take on, the questions are about the role of states, really. One specific question is about Minnesota. Stefan Gildemeister, who's the director of our health economics program in our Minnesota Department of Health. Thank you, Stefan, for that question. So Minnesota had a discussion about the 340B program a few years ago that ended in a stalemate. No new data collection authority. What are state policy interests in better understanding the volume and working of the 340B program on the ground? And another very related question is about, are you aware of any states working effectively to gather 340B data? So data collection for states and what can we do with that?
Yeah, sure. But I think I can answer these questions and then segue into some of the trends in litigation also. And please, if Dr. Sayah, if you have anything else to add. In terms of, there are many stakeholders in these litigations, and states are one of them. In fact, one of the states, did take some action. Arkansas decided to enact, the legislature in Arkansas enacted a new law that said that manufacturers cannot restrict 340B prices in Arkansas to pharmacies that are in contract with covered entities, effectively adding contract pharmacy as an additional covered entity. Whether Arkansas had that authority or not is now in courts. Again, the Trade Association for Pharmaceutical Companies, Pharma, they sued Arkansas to answer this question. And it begs the question, like, what is, as the questioner asked, well, what is the state's interest? And I really think states, the states have certain costs in two separate areas. One is Medicaid, and as we saw with duplicate discounting, Medicaid and 340B prices are, they're two sides of the same, or rather, you can have one and not the other. And if it's clearer, the data is clearer on where 340B drugs are being discounted, which ones are being discounted, it'll be easier to understand what Medicaid dollars are going in the right places and which one, what drugs can get reimbursed at the full price and not at a rebated price. Also, states are also interested in, taking care of their providers, and maybe Tom can also touch on this. But any money that's going, any money that these providers are getting from their from this 340B program is money that the state does not have to then spend in supporting these entities. So I think from that perspective, it might be a good idea to get more data on this. In terms of the litigation itself, we have seen that other than this, what Arkansas did, HRSA has appealed at least one of the rulings that came against it. I think eventually these questions will go up to the circuit courts, and from what we see so far, there may be a split in the circuit. So that split may stay, or the Supreme Court may get involved. Maybe in the next cycle of the Supreme Court or the one after, we'll start seeing some of these questions, more definitively. Well, I can't really say definitively answer. There's a lot of space over here for the legislation and Congress to also answer some questions. But we'll have a clear understanding on something that can apply throughout the country. I also know that the OIG is involved in some respect. They have some questions that they have to answer. Right now, what we see, a trend that we are seeing is, even though the manufacturers are restricting who they are sending, they're giving 340B prices, the program keeps expanding. It's still continuing to expand in terms of the total amount of money that's being that's coming through the program. And so far, on the manufacturer side, I think it's over a dozen manufacturers are now restricting their prices, who they give the prices to in some way or another. I think the last count, it was 14 manufacturers are doing that.
Thank you so much, Faraz. And Tom, if you could take just a few minutes, we're almost out of time, but want to really hear your perspectives on, do you think the Congress will intervene on this topic, and what other actions we may expect from HHS and HRSA OIG?
So on the congressional side, I think it's going to be difficult to expect Congress to do very much, because everything in Congress seems very partisan these days. And although the 340B program generally does have bipartisan support, I still think it would be difficult to legislate in this area. Maybe at an absolute minimum, maybe giving HRSA some more regulatory authority. I mentioned in my presentation that HRSA doesn't have a lot of regulatory authority. Perhaps Congress could say to HRSA, you have authority to issue regulations in the following areas. That might be helpful, because then anything that HRSA does have some level of deference that would be afforded to it. In terms of HRSA and HHS doing anything further, I think they're going to let the court cases that Faraz went through, I think they're going to let those cases play out. I don't think they're going to interfere any further. The OGC opinion that Faraz mentioned actually got withdrawn when the Biden administration took office, and I think in part that was because they wanted to see how the court cases were going to play out. I'm guessing that that's what's going to happen, because if they issue another policy, some court somewhere in the country will invalidate it, and so there's no point in doing it. I think we're going to have to wait and see how the courts decide these cases. There's plenty more I could say, but in the interest of time.
Thank you so much. This was just such a wonderful panel to be part of. Thank you, Tom. Thank you, Faraz. Thank you, Sayah, for your time, for generous time, for really walking us through this complicated, intriguing, and a lot to come topic that we will all watch closely. And finally, I want to thank our audience again for attending this virtual event. We hope that you found our topic and speakers informative and engaging as much as I have personally found. And we hope that you were inspired by it. And really, please consider following BACH on our social media and our upcoming events. We would love to do more events like this, where we really explore these intersections in healthcare, where we bring in the academic and research perspective and the gaps, where we bring in, in this case, the litigation and some of the issues on the policy front and how that intersects with the business. So thank you so much for your time. And we will post the recording, as well as Sayah has kindly agreed to post her slides as well on our event website. So thank you very much. Have a very good afternoon.
Thank you.
Thank you. Thank you, everyone.